I'm Alan Gassman. I'm sorry to disappoint you that Brandon Ketron is not here, but the dummy is here and I'm going to take Brandon's place. You're actually not as smart as Brandon, but you don't earn as much either. So today's program is the greatest hits of estate tax planning, also known as more of the same, but I'm going to give you some new things this week as well. So please go ahead and send me emails if you have any questions. I'll check my emails towards the end of the program, and I will also be checking the questions. So I apologize that our videos aren't working today. Nothing new there. Yes, this program does not qualify for continuing education credit. And if you have questions, you can click on the questions panel there, and then you can type in the question. And if I know the answer, I'll answer it. And if I don't know the answer, then I'll pretend I didn't see it. We also have some handouts. And if the handouts are not working for some reason, we will email all the handouts out to you. Now, this is a free presentation. Friday, August 20, a not so free presentation will be representing the distressed business. This will be especially good for clients who have distressed businesses or advisors who do represent distressed businesses. Now, that's not being upset and having to go see your psychologist. This is when you don't have enough money to pay your bills, or you may want to buy one of these businesses out of bankruptcy. We'll be talking about how to do that, why to do that, when not to do it. Also, Brandon and I have updated our materials on PPP and employee retention credit. And there's a 90-minute Lineberg webinar on that you may be interested in. A free webinar with one of my better friends, Lester Perling. We'll be talking Wednesday, August 25th on structuring medical practices under the Stark Law, which has always been an interest of mine. Lester and I wrote a book about that a few years ago, and we may actually update it. So thanks for attending these Saturday morning sessions. Very much appreciated. Everything we do is recorded on YouTube. You can go to YouTube and watch us there. And I'm very excited about this next program I'm going to announce here. On Friday, October 8th, virus willing, you can join us in Naples, Florida at beautiful Ave Maria Law School. The time's been changed. It's from noon to 5. We're going to have what we call our third professional acceleration workshop at Ave Maria. It involves both students and alumni and friends, and we're going to get into workshops and breakout sessions on how to reach goals, how to eliminate frustrations, how to solve problems, how to attract clients, how to develop a great team, putting it all together. And then number 7, a special hour for estate planners. This is a lot of fun. There's a lot of breakout sessions, a lot of creativity, a lot of humor, and a lot of personal relationship and professional skills that the students actually want to learn and that the experienced lawyers, CPAs, and other professionals always enjoy. And Notre Dame Tax Institute, October 20, my partners will be speaking on slats, and I'll be speaking on tools and strategies to avoid ethical issues with Jonathan Blattmacher. Finally, Tuesday, August 31st, a free webinar with Marty Shinkman and others, a preview of the Notre Dame planning, and some very interesting stuff, both for laymen and professionals. So that'll be 4 p.m. August 31st. It'll be on the Lineberg program or directly through Marty Shinkman. Please feel free to join us. So I thought I would start with some new materials here, and here I go. Number 1, what is the estate tax exemption? That is the amount that can pass estate tax free when somebody dies as a U.S. citizen. $11,700,000 per person passes estate tax free, minus any countable gifts you've given in the past. What will this exemption be next year? Well, if Congress and the president don't do anything, it's going to continue. It'll be about $11,920,000 next year, based upon historical inflation. And then in 2026, it'll go down to half unless Congress and the president do something. Bernie Sanders would bring it down to $3,500,000. So the answer is, we don't know. Number 2, what's the gift tax exclusion?
Right now, the estate and gift tax exclusion are a unified system. You could give up to 11,700,000 minus what you've given in the past that's been countable. That counts against your estate tax exemption. How much will it be next year? We hope it stays the same, goes up by 2% or so on average. But Bernie Sanders would have brought it down to 1 million because they want people to keep their assets in their name so they can get the estate tax when the people die. So if you're going to use that gift tax exemption and you know you're going to use it, or you probably should use it, or you probably should have used it, stop procrastinating. Get it done. There's a great video. Dan Sullivan of Strategic Coach has a great video. Go to Google and type in "get ready to get ready." And Dan says, you know, there's people who get stuff done, and then there's people who want to get stuff done, but they're not quite ready to get ready. So first they're going to get ready, but first, before they get ready, they need to get ready, and then they might get something done. Well, get it done if you're going to do it. Number 3, the annual gift tax exclusion. I can give $15,000 a year to each person I know and love, and relatives also, in addition to those people I know and love. And I could front load that for a 529 plan. If I put $75,000 in a 529 plan for my granddaughter, I can count that as a $15,000 gift this year and $15,000 a year for the next 4 after this. If I die in the middle, it does get backed out, but this is something that would be grandfathered in because Bernie Sanders wants to limit this gifting to $50,000 a year cumulatively per donor. So if you have 20 kids and grandkids, you'd be out of luck under his plan. That's the annual gift exclusion. What's the portability allowance? Has nothing to do with mushrooms, although I like mushrooms, especially the ones you eat. So the portability allowance, if I die and I leave $5 million to a credit shelter trust for Marcia and nothing else, because she has all of our other assets and she's going to keep it that way, then what happened to that $6,700,000 exemption? She gets it. Now her exemption goes from 11,700,000 to the sum of 11,700,000 plus 6,700,000. That's 18,400,000. But the exemption she got from me won't grow with inflation, does not allow her to give GST exempt gifts. In other words, if she uses that to make gifts, they'll have to be to trusts that get taxed at the level of our children when our children die. And in addition, if she remarries and her new spouse dies before her, she will get the new spouse's portability allowance instead of mine, even if it's 0. So that's the portability allowance. I prefer to use the estate tax exemption into a credit shelter trust for creditor protection planning. It grows with the investments, but in a credit shelter trust on the second death, you do not get a step up in income tax basis. So I die with 11,700,000 in an exemption trust for Marcia. If that grows to 30 million when she dies, that's out of her estate tax, but out of her estate for estate tax purposes. But when she dies, does the 30 million get a new income tax basis? And the answer is no, not under the present law. If the estate tax goes away, then the provisions under our credit shelter trust documents allow a special person called an independent fiduciary to give Marcia the right to appoint assets to creditors of her estate, which will cause the assets to increase in basis. So this whole concept of whether to take the portability allowance or not is complicated and important. The real solution, in our opinion, is to make sure the estate tax planning documents allow a decision to be made after the first dying spouse's death, where you could have those assets be considered as owned by the surviving spouse and use the portability allowance, or be considered to go into a credit shelter trust. And you can do that, in my opinion, with all of the couple's joint assets by using what we call a joint exempt step-up trust. So the tax lawyers and CPAs know what I just said. The rest of you, I apologize. It can be summarized by saying it's a little bit complicated. Page 23, the Credit Shelter Trust, also known as a bypass trust, also known as a B trust. I die, I leave it to Marcia as sole trustee. She gets whatever she needs for health, education, maintenance, and support for herself. She can give it to anyone else other than her creditors and creditors of her estate. And it will not be subject to estate tax when she dies, and it won't be subject to creditor claims, and her next spouse will have a hard time reaching it, if they could at all. Number 6, do not allow assets to go directly to your children. You can't trust them. You already know that. But even a responsible child doesn't want to receive an inheritance outright, because it could be lost to a creditor, lost to estate tax, lost to a divorcing spouse, lost to an overly aggressive person who you may meet in life. So the child can be the sole trustee, have the right to receive amounts as needed for her health, education, and maintenance, the right to direct the assets during the child's lifetime, and it's not subject to estate tax or creditor claims. And if you want the child to get a step up, you can give the independent fiduciaries the power to give the child a power of appointment over the trust assets. Which reminds me, let's say I set up an irrevocable trust for Marcia. It's for her health, education, and maintenance. I fund it with my $5 million of remaining assets. Now I have nothing. Those assets are not subject to estate tax in her estate. We make her father a beneficiary of that trust. He has the power to appoint the trust assets to creditors of his estate, but only with the approval of a couple of other people we know. Marcia's father passes away, full step up of income tax basis in the assets of the trust. That's called the OBIT trust, OBIT, invented by Ed Morrow. Really neat stuff. Number 7, the irrevocable life insurance trust. I put my life insurance in an irrevocable trust. I have Marcia or my brother or my friend. If I had a friend, I could appoint a friend to be the trustee, put the life insurance ownership and beneficiary in there. If it's a new policy, it works right away. If it's an existing policy that I've owned, it takes 3 years before it works. I transfer the ownership of the policy and the beneficiary designation to the trustee of the trust. By the terms of the trust agreement, on my death, it's held for Marcia's health, education, maintenance, and support, and is also distributable for our children. It's never subject to the estate tax. So let's say that the exemption is $23 million. It's never going down, and I only have a $10 million estate, and I have 10 million of life insurance. So when I die, I'll have 20. Marcia and I have plenty of exemption. Why do we need a life insurance trust? Well, the reason is because the amount of life insurance outside of that trust will reduce Marcia's portability allowance. Like if I die with 5 million of assets and 5 million of life insurance, her portability allowance is only $1.7 million. But if I die with 5 million of assets and 5 million in a life insurance trust, then her portability allowance is $11.7 million. Or that's $6.7 million, sorry. That buys a lot of portobello mushrooms. So that would be a reason. Now, what if I have a cash value policy into the life insurance trust? I could pay the premiums by loaning the money to the trust using what's called split dollar advances. And I can charge a very low interest rate. Right now, the rate is about 1.5%. And I don't have to collect interest on that from the trust until I die and the policy matures, which will be a sad day for some and not so sad for others. But then if I need the money while I'm alive, the trustee borrows on the policy or cashes it in and repays me my loan. And that's called a split dollar loan. Now, a more aggressive use of split dollar is that my daughter, age 37, decides to buy a $10 million life policy, and it costs $1 million to buy it. and I loan her life insurance trust $1 million, and I'm going to get my $1 million back plus interest at 1.5%, compounded only annually, when my daughter passes away. Well, my daughter's 37. So realistically, that's 55 years from now or longer. What would you pay me for the right to receive 1.5% interest for 55 years on average, and then $1 million after 55 years? That thing isn't worth $300,000. So what happens now? I die. They value that split dollar interest in my estate at $300,000. So I've saved $700,000 in estate tax, and I've moved assets to her. Now I could do that a bigger way. I put $10 million in the trust. She buys $100 million worth of life insurance. And now I transfer my right to be repaid to a partnership. It's only worth $3 million. I sell my 99% partnership interest to a trust for my wife for $3 million. I've just moved $7 million out of my estate without paying any gift tax. Is it too good to be true? Well, according to the Morissette case, it was too good to be true for Mrs. Morissette. But in her case, the judge said that the lawyer made a mistake. The lawyer provided that when Mrs. Morissette died, she continued to own the repayment right, and it went directly to the trust that owed her the money and canceled it out. So I'm not a big lover of permanent life insurance, but wanted to let you know about this aggressive technique. Now, number 8, by the way, is everyone awake? Hey, you, wake up. Okay, number 8, what is community property? Well, if you look at the historical law of Spain and France and the ancient country of California, you find something called community property. And in a community property state or country, the spouses, the husband and wife usually, or the husband and husband, or the wife and wife, when they acquire any assets, when either of them acquires any assets during the marriage, it is called community property, and it belongs to both of them. And under an anomaly under the federal income tax law, going back to the 1940s, when one spouse dies, all the assets get an income tax basis step up. So Marcia and I moved to California. I work hard, save $1 million. It's in my name only. I die. It's half Marcia's under the community property law. On my death, she gets half of it, no matter what my will says. And all of it gets a new income tax basis, so she could sell the assets right after my death and not pay any capital gains taxes. Well, most of the states in the United States are not community property states. Florida, New York, New Jersey, anything that starts with new, Georgia, these are not community property states. So if I put all my assets in Marcia's name to avoid creditor problems in case I'm sued by somebody who really hated the webinar and sued me for emotional distress, then you can't touch the assets, but when I die, Marcia gets no step up because we didn't do this in a community property state. Well, there's a new possible solution for that, and that is the community property trust. And a very, very bright, very popular lawyer named Jonathan Blottmacher went to Alaska years ago and caused Alaska to pass a community property trust statute. So you could put your assets in a community property trust in Alaska if you are married, and even though they belong half to each of you, if one of you dies, you get a full step up, according to Jonathan and according to the Internal Revenue Code. Not 100% definite because of a US Supreme Court case from the 1940s called the Harmon case. The IRS, in their instructions to community property handling says they're not so sure what happens in a community property trust. But Florida just passed a Community Property Trust Act on July 1st of this year. So clients who aren't sure who's going to die first can set up a community property trust, get a full step up on the first death, but only half of the assets in a community property trust can go into a credit shelter trust. We invented something called the JEST Trust, a joint exempt step-up trust, where Marcia and I could put our assets in a joint trust, which could be owned, say, 5% by me, 95% by Marcia. But due to the bells, whistles, mirrors, and smoke that we put in this trust agreement, if I die first, number one, we think all the assets can go into a credit shelter trust up to the full 11.7 million. And two, we think there's a full step up for all assets. So even clients living in California, Texas, and other community property states are using JEST Trust to get a full step up on the first death without being in community property for two reasons. One, on the first death, you get a full step up, but you get that in community property too, so that doesn't count. Let me try again. Number one, in a community property state, when you die, half the assets have to go to your wife, which you may not want, or your spouse rather, which you may not want. And number two, this is horrific, by the way, in a community property state, if they're all the assets are in my name, in my example, I earned them, Marcia's in a car accident, they can sue me and get all the assets because it's community property. So if you're living in a community property state, think about transmuting out of community property status. Okay, have some questions here. Jeffrey says, regarding use of portability versus the credit shelter trust, it's been suggested that if the surviving spouse were to use portability with respect to the first deceased spouse, the surviving spouse can create a grantor trust in the amount of the portability allowance and deplete the survivor's assets by the tax burn on the grantor trust. That's true. So I die, Marcia takes the whole 11.7, she puts it in a new irrevocable trust using her gift allowance, and then she can pay the income tax on that trust income. But the problem is she can't really safely be a beneficiary of that trust unless she lives in an asset protection jurisdiction or you are absolutely sure that this will work. But I agree, Jeff. And Jeff, you should give one of these webinars because you know as much about this stuff as I am. Paul, thank you for telling me you were awake. It's a surprise. What are the reporting requirements for a JEST when the parent dies? It's pretty much the same as a credit shelter trust. You don't have to file a gift tax return, or at least I don't think you do. You would file an estate tax return to allow the portability allowance to work to the extent you're going to use the portability allowance, but otherwise it's pretty much the same. Okay. Number 9. Please put your assets under LLCs, limited partnerships, or other entities. Number 1, limit liability for dangerous activities. If I've got a rental house, it's not going to be in my name or Marcia's name. It's going to be in an LLC, and we're going to have one of our nephews and nieces be the manager of that LLC and handle that difficult tenant. B, divide ownership among entities like trusts and people. We'll show you some layering later. C, get discounts by using voting and non-voting stock. Maybe Marcia and I will own 99% of that LLC as non-voting members. We could have an irrevocable trust for our daughter, own 1% as the voting member. And then when we die, there would be a significant discount on the value of the LLC interest. D, always use charging order protection when you can. If you get a judgment against me as a Floridian and I own 98% of an LLC and Uncle Floyd or a trust for my children own 2%, then if you get a judgment against me, you can't reach the 98% interest. You can only get a charging order. It's not a good thing for me, but not as bad. You can't reach into the entity and you can't take control over the entity, and you might even possibly have to pay income tax on the entity's income, although that one's a long shot. E, When we set up LLCs for clients, we ask them, do you want privacy? Do you want people to be able to Google Sunbiz, S-U-N-B-I-Z, Gassman, G-A-S-S-M-A-N, and then the Sunbiz website comes up, and every company I'm involved with comes right up on the Sunbiz website, straight from Google. On the other hand, if that LLC is in Wyoming or Colorado or Delaware, they don't list the manager. They don't know the manager. They don't know the owner. So a lot of clients have their Florida LLCs managed by a Wyoming LLC. So when you go to Sunbiz, you don't see the client's name anywhere. And by the way, I'm pretty sure that Nevada has done away with the privacy. If I'm correct, the Nevada Secretary of State now requires you to inform Nevada who the manager is. So I'm going to have to ask my friends in Nevada if there's a way around that. Otherwise, my Nevada LLC clients may need to have a Wyoming LLC as the manager of their Nevada LLCs. As Bob Burke, one of my mentors, said, Alan, for every complicated situation, there is a simple answer. And it's almost always the wrong answer. Complicated situations call for complicated solutions. So I thank Bob for that and for a lot of other things he taught me. Number 10, make gifts to irrevocable trusts for the following reasons. A, it's a great income producer for your lawyer and maybe even your accountant. B, why would you give those children who you hardly even like and certainly don't trust $15,000 a year or $1 million if it could go into a trust that would protect them from creditors and estate tax, etc. B, also avoid estate tax, avoid creditors, and avoid predators. Avoid predators. I had 2 situations last week with aggressive housekeepers. One aggressive housekeeper loves him and he would like her to inherit everything during the 12-minute intervals when he remembers who she is. So his assets are going into an irrevocable trust managed by his nephew only for him so that he cannot give that housekeeper his hundreds of thousands of dollars worth of assets. Had that happen twice this week for 2 different clients. You want to be a multimillionaire in Pinellas County, Florida, become a housekeeper in an over 55 community for elderly people and give them a discount if they're over 80 and single. And you will be a millionaire within a year. Page 26, sell assets to an irrevocable trust that's disregarded for income tax purposes. Number 12, the above only touches the tip of the iceberg. Don't be the Titanic or F. Lee Bailey. Why F. Lee Bailey? F. Lee Bailey had a very great book I read in middle school. It was called The Defense Never Rests. And in that book, F. Lee Bailey described all of his famous cases up through the time. And he talked about how he worked extra hard investigating and looking at the law, talking to other lawyers to find solutions to problems that other criminal lawyers had not been able to solve. That's the first thing I learned from F. Lee Bailey. The second thing I learned from F. Lee Bailey is many times in the book, he says, anyone who does her own legal work has a fool for a client. And whimsically and unfortunately, years later, F. Lee Bailey did some of his own legal work and had an ethical issue and ended up with a criminal conviction. So don't do your own legal work or you will have a fool for a client. And number 13, reflecting on my Ave Maria talk in October, 5 hours interactive workshop on goals and achieving goals. Set a goal, and one goal I hope is the protection of your family. If you're a client or a layman watching this, you know what I mean. You get so involved with the business and the pleasure and the social events that you just haven't really sat down with a piece of paper and a pencil and said, what are the goals for my family and how do I achieve them? Are they protected? Are they protected from taxes? And what happens if what happened to a client 2 weeks ago happens, by the way? He was taking a walk and died instantly from an aneurysm, age 72. Instantly. No time to say, oh my gosh, I'm really sick. I need to get my will updated. No time to sit down with his wife and say, hey, here's where we are. Here's what you should do with the business. He had no time for that. He died instantly of an aneurysm. So as my friend David Finkel says, you have A time, which is the most important time, B time, which is what most people do most of the time, and C time, which is the distractions. My gosh, get rid of some C items and get some A items done, which includes making sure that you have all the right insurances, that your spouse knows what to do if you die, besides be happy or sad, and that your planning documents are coordinated with your beneficiary designations. So what next? Well, we've got the spreadsheets here for you. I was going to have them loaded and show you how they are used, but they are not loaded. But you can use these spreadsheets. We're going to email them to you. And what you do is you can put in any dollar amount you want for your net worth. You can increase it by an annual growth percentage, and then you can compare it to what the exemption now is, what it's going to be if it goes to half in 2026, and what happens if it goes to 3.5%. So that's for a single person. And we also have that for a married couple. And you don't have to know anything about Excel, because Excel has arrows. And you and your arrow, which is a great song by Harry Nilsson, one of my favorite songs by Harry Nilsson, Me and My Arrow. Me and my arrow, straight up and narrow, can decide what to do with the estate tax, which is harrowing. Well, anyway, rhyming, not so good, but this exemption thing, really good. Go ahead and give it a try. And we also have a Cupert chart. We'll get back to Cupert. The Estate View software, if you're a client, you can use it for free. We'll be glad to send you the login and the instructions for it. It's pretty interesting stuff. Just let me know. Be glad to share it with you. Okay, some questions. A person gives away 10 million and files a gift tax return. Time passes. The law changes. The exemption is lowered to 3 million. The person dies. Is there a $7 million clawback? No, there's no clawback. No clawback. That's good. What happens if the decedent's estate now has only 500,000? Persons who received it in the 10 million are long gone or have spent it. Well, the person dies, they have no exemption now, so they're going to pay estate tax on the 500,000. That'll be a $200,000 tax under the present law, unless they give it to their spouse or charity or spend it on legal fees, which is another great planning opportunity. Page 35. Client wants to make a profitable rental property, an LLC, pass it to his children. He's in his early 90s and in good health. He's slowing down. I hope I start slowing down in my early 90s and not until then. He's not overly concerned about the estate tax. He won't have to pay it. He's maintaining his estate below 8, but his estate will be well above the Washington state estate tax limit. Well, the answer is obvious. Move to Florida. Could setting up an LLC as a partnership and then transferring it to an irrevocable trust for the spouse and descendants reduce his estate for state estate tax purposes? Heck, yes. In fact, for example, New York has no gift tax, but a huge estate tax. So this planning in a state like Washington or New York, which do not have a gift tax but have a large estate tax, is perfect. And if this was Bill Gates, have him call me on the weekend. I'll be glad to talk with him. Page 36, I'm 71 and want to help my daughter. She's single. Okay, well, I'm single. I'm married. I can't help her with that. She'll soon be 35. Okay, that means she's 34 now, I think. My plan was to set up a trust in the amount of $360,000 At age 35, she may get $1,000,000 a month for the next 30 years. Heck yeah, till she reaches 65. At 65, she can take what remains. What do I think of the plan? It's a great plan. The question is there the discipline to only spend that amount? Do you set that in stone? You can go to the Vanguard website and buy a life annuity for her that may pay $1,000 a month for a lot longer than age 65. But how do you keep up with inflation? Should it be $1,000 a month plus inflation at the inflation rate? Or what happens if she needs a lung transplant or she's going to die? Should you appoint a trust protector to be able to handle that? Those are all considerations that we think about. Okay, number 2, I'm required to take my required minimum distributions from my simplified employee plan at 72. I can mitigate taxes by giving it to charity. Yes, you could take money this year. You could take an unlimited amount out of your IRA, let's say 10 million, and then make a $10 million donation to a family charitable operating agreement, which is an active family charity controlled by you, get a full tax deduction for 10 million and pay no taxes. Otherwise, it's going to be, after this year, it goes back to up to 100,000 a year, going from an IRA to a public charity or a private operating foundation. Thank you very much for asking. Now, here's a couple of new hypotheticals. I know a lot of you are planners and a lot of you are clients and friends. And this is one I'm working on this week. The client today has a $6 million IRA, and that's about all he has. He also has about $2 million in low-cost variable annuities that he doesn't want to cash in because he's going to have to pay tax on them. That's what he's got. The wife owns 70% of a limited liability company, which has $6 million in assets. So they're not estate taxable now, but they definitely will be if the assets double twice in value over the next 20 years, and certainly if they have a reduction in the exemption in 6 years. But he only has an IRA, which you can't gift without triggering income tax, and he has these variable annuities, which he paid $500,000 for. Now they're worth $2 million. If he transfers them to her, he's going to pay income tax. So what are we going to do? We're going to set up a spousal limited access trust. The wife is going to be the beneficiary of this trust, and we want the husband to make a contribution to the trust. So what contribution is he going to make? He's going to give the wife a $3,750,000 promissory note, and in exchange for that, he's going to receive 70% ownership of the family limited partnership. And then he's going to transfer that 70% ownership in the family limited partnership to this SLAT, which will pay whatever is needed when needed to the wife for health, education, and maintenance. In addition, he is going to put the $2 million in variable annuities into the SLAT. It's not the most efficient asset, but the problem is when this grows to 4 million and then 8 million over the next 20 years by doubling twice, which is the rule of thumb, at a 7.2% rate of return, investments double every 10 years. Then that's going to be a very large asset. So what we've done is we've given the wife a note for $3.7 million. We put the FLP in there. We put the variable annuity in there. We could also put half of the home in there. They've got $1.8 million home. Now he has to pay rent for use of half of the home. So this is all going to be out of the estate for federal estate tax purposes. And I do apologize, there will not be a note in this SLAT. It'll be an FLP interest. Now the spouse has a note from her husband. She can hold it over his head. If he dies, then the IRA is going to go to the wife by rollover so that we won't have to pay income tax on the IRA. She can take it out over her life expectancy, and she can put her half of the home into a Cupert. So that's what I think we're going to do for that client. I think it fits because when you run the numbers and everything doubles, she'll be living off of the IRAs. They're also very charitable, so anything that puts her over the exemption, she'll be able to donate to a foundation. So I think this works. Now, here's another one, and I was working on this one yesterday with the client, and then today. And here's where he stands. He's 67. He's in a fantastic second marriage. He has cash of $600,000, IRA of $433,000, home worth $2.8 million, personal condo $980,000, total personal assets and cash $4.7 million. Hanging out there, exposed to estate tax, vacant lot worth $1.8 million, variable annuities worth $3.3 million, and 25% of a family partnership, which is worth $3 million without discounts. The partnership has $12 million, but he owns 25% of it, which is worth $4 million. But if you take a discount because he doesn't own the general partner interest, we're going to say it's worth $3 million. He could take these assets here that are worth a total of $8 million, put them into one or more LLCs, which would be disregarded for income tax purposes so that we're not causing taxation of the variable annuities, and then take a 30% discount, and that 99% LLC interest of the LLC that's going to own these assets will be worth $5,670,000. Now, here's what he has outside of the estate tax: assets worth $8.5 million. He's got 75% of an FLP and a Nevada trust for his children and spouse. He's got a trust his mother left him, and he's got some 529 plans. So before this plan, and by the way, if he sells the 99% interest in the LLC, which owns these assets, he can take back a $5,670,000 note. And it can bear interest, if it's a long-term note, at only 1.2%. Well, the problem, quite candidly, here is he spends a lot more than a 1.2% of $5.6 million. He would like to be able to spend $300,000 to $400,000 a year without touching his Nevada trust. So we can use what we call a self-canceling installment note, which would be a note. Because of his age, it would have to balloon within 16 years. It can pay an interest at 4.934% a year. So at 4.934% a year, he'll receive approximately $260,000 a year. It's tax-free because it's going to be owed to him by the Nevada trust or another trust. And when he dies, the note will disappear. It goes nowhere. Now, our standard software tells us that the life expectancy is 16 years. And if you use the life expectancy for the balloon, there's the interest rate, 4.934% if we do it this month. But what if we go with a 20-year note? Because he needs more cash flow. Then the interest rate's going to be higher. I'm going to ask my friend, Professor Jerry Hesh, to calculate the interest rate for me because I don't remember how to do it from law school. It's got to be done by hand. I'm guessing it'll be a 6% rate of return. 6% on $5.6 million is about $350,000 a year. And if he dies within the 20 years, there's no estate tax on any of these assets. And these assets on the left can pass to his spouse and qualify for the marital deduction. So this will put him in an estate tax-free situation. Here's what it looks like when we're done. We've put the variable annuities in one LLC, the vacant lot in a second LLC. Yes, the variable annuities are going to be subject to income tax when they come out, and they'll have to come out sooner when he dies than rolling them over to his spouse, but he doesn't want to roll it over to his spouse. He wants the remainder interest to go to his children. So I put the variable annuities in LLC 1, the vacant lot in LLC 2, so they don't get, so if somebody trips and falls, we don't lose more than the vacant lot. The FLP interest gets sold to a new trust. I do a new trust. One reason I do the new trust is that if these assets fall in value, we don't lose assets from the old trust. Secondly, the new trust can be more liberal in the benefit of his spouse. In fact, the new trust could be a Florida trust, wouldn't have to be in Nevada. The client probably doesn't need to access this trust for anything since he can access the Nevada trust. So this can be a Florida trust. The spouse can be the trustee. He won't have to incur Nevada trustee fees, but those can be as low as $500 a year. The alternative would be a private annuity that would pay him about 7% of its day one value each year. So I think that's what I'm going to suggest for this client. I think it works well. Now, David says, is it the fact that the SLAT is a grantor trust? There's no income tax implications in the annuity transfer. That is correct, David. Because the variable annuity is a asset that has to be considered as owned by him to continue its tax deferral during his lifetime. We will have it owned 1%, by an LLC, owned 1% by him, 99% non-voting by the Nevada Trust, which will be disregarded for income tax purposes. When he sells the lot, the capital gains is going to end up paid by him. So he's going to need a prepayment on the note to pay the capital gains tax when he sells the lot, unless he does a 1031 exchange or an economic recovery zone. So we need to make sure to tell him about this. And when the annuities are cashed in, slowly or quickly, the income tax will have to be paid. And that's going to be paid by him. So we'll have to budget for that. When I think about his particular situation, I am probably going to keep the variable annuities out and in his name and simply have more go to a marital deduction trust to pay only income to his spouse if he dies and there would otherwise be an estate tax. So we're going to talk about that. But I think that this is a good one, a good example of one that was not easy to plan. And he has a much more complicated chart, but what I actually had to do this morning was sit down at my desk and draw little circles. And I have carbon paper, so I can have 3 copies of what I drew and then go step 1, step 2. But that's good stuff. What we're doing the most of, and we've said it many times, this is a relatively young couple. They have good earnings. They have good savings. $6 million goes into the LLC. We could make it more if a note was transferred to the LLC. And then the husband sets up a SLAT. We usually have the male client who is older and less healthy, shorter life expectancy, sets up a spousal limited access trust, transfers 70% ownership in this limit LLC to the trust. That should be worth $4.2 million without discounts, but we call it lower. In exchange, he gets a note. He could put his house in there, pay rent, and when these assets grow, we save federal estate tax. We don't get the step up in basis when these people die for the assets that are under the SLAT, according to most of my colleagues. According to Jonathan Blattmacher and Howard Zaritsky, there's just as good a chance of getting a step up in basis on the SLAT and irrevocable trust assets when the trust is disregarded as there is that there's not a step up. So we think that the responsible way to report this is that there is a step up when the client dies under the present law. And there is not substantial authority to the contrary, according to Howard Zaritsky. So all of these advisors out there who have clients die when the client was considered the owner of an irrevocable trust and are not providing the step up, I think you're taking a risk. I don't think that's in the client's best interests. Will the step up always be there? No, I think eventually the IRS will come out with a pronouncement, and then there will be substantial authority, and then you'll have to disclose it on the tax return. That's how that works. 9 minutes left. You can go to our YouTube channel and see the August 7th webinar that Brandon and I posted on the new PPP laws and the new ERC laws. If you're a client, let me know and I'll send you a free copy of our Employee Retention Credit Guide, which we just republished last Monday, and now we're going to have to republish it again this Monday because of an IRS pronouncement that came out Tuesday. I think most of you don't really care about this. A lot of the advisors do. So there is something cool. The recovery startup business, a business that started after February 15, 2020, that averages less than $1 million in receipts on an annualized basis, can get wage credits of up to $7,000 per quarter per employee, even if they're making a fortune, up to $5,000 maximum per calendar quarter. So definitely check that out. I think there's going to be a lot of PPE clients and other clients who made money, set up new businesses to handle issues under COVID-19, and now get this recovery startup business. Pretty cool stuff. Okay. A lot of things that we've handled over these months, a lot of things that I will not repeat, but I put it in here. Please remember that stuff happens. When a building falls on somebody, the limits of liability are not necessarily what is going to apply. So please get these pieces of real estate into separate LLCs. Let each LLC owe money to the parent entity, so that, for example, this building worth $10 million has a $9 million note owed to the parent entity. Somebody slips and falls, they force a sale of the building. The first $1 million will go to the new creditor. The other $9 million is going to go to the real estate FLP. It's as easy as that. It should work. May not, but it should. And it's very inexpensive to put that type of thing into place. Always, when you do your client's estate and estate tax planning, think through the asset protection planning. It's like that three-dimensional chess that Mr. Spock was always playing on Star Trek. I never learned to play three-dimensional chess, but I've done a fairly good job being conscious of the fact that I'm trying to plan an estate where there is no estate tax and no access to creditors. So sometimes that only takes a few moves, not such difficult moves. Now, we do use irrevocable trusts that are complete gifts, which means once I gift it, it's not in my estate. It uses up part of my $11.7 million. And it's in my home state, which is not a creditor protection state. It's shielded from creditors. But if I want to be a beneficiary of that trust in case things go terribly or I get divorced, then it needs to be carefully drafted, and it needs to be in an asset protection jurisdiction, such as South Dakota, Nevada, and brand new, I'll be reading tomorrow about Alabama's new act with only a 2-year look back. It looks like a pretty strong act. So that banjo on the knee, the banjo can be assigned now to an Alabama creditor protection trust, including all of the red clay. That's good stuff. But there's also, please remember, the irrevocable incomplete gift trust for creditor protection planning. So let's say the client wants to put 10 million in a complete gift trust and has another 10 million left. Well, set up another asset protection trust at the same time. It's almost an identical document, except the client A has the ability to veto distributions. B has the ability to appoint where the assets go when the client dies. C, the client controls who the trustee is, and the trustee has the power to give the assets to the client. But that qualifies as an asset protection trust under Nevada, South Dakota, Alaska law, and makes it hard, maybe not impossible, maybe impossible, for a creditor to reach into that trust. And it's not a taxable event to fund the trust. It's an incomplete gift trust, but it could become a complete gift trust immediately before the gift and estate tax law changes at a drop of a hat. Or if the client is under threat, then the trust agreement can say that she no longer has the ability to change trustees. And the trust could even say that if the Nevada trustee resigns, it has to go to an offshore trustee. Offshore trustee is not going to give any money to anybody. They don't even recognize U.S. judgments. So these are somewhat popular, right time, right place. Then there's the spousal asset preservation system. So many clients, when you say to them, do you realize that if one of you dies, the survivor has a lot of assets and can leave it to the next spouse? And the client looks at you in a surprised way and says, what? Are you kidding? I don't want my assets to go to the next spouse. Well, that's where the client signed the marital asset preservation agreement, which says when one of us dies, the survivor will fund an incomplete gift trust for the benefit of the survivor and descendants to protect those assets from that terrible, awful, nasty next spouse and their adorable children. So now my spouse dies. I have a business reason. In fact, I'm contractually required to fund this trust in an asset protection jurisdiction. It is not done for the purpose of avoiding creditors. It is done to obey the contractual agreement that I have entered into with my spouse. And that's a very good thing to possibly do. If you really want an asset protection trust to work, put it offshore. It's not that much more difficult to draft an offshore trust or to administer it. It's just expensive to do the income tax compliance. And if you make a mistake in the income tax compliance, the penalties can be huge. But if your client has a good business reason to use an Isle of Man trust or a Nevis trust or a Belize trust and wants the stronger protection, then it is certainly an appropriate instrument to use. So with 1 minute left, please think about page 101. I hope you've enjoyed this presentation. I can't imagine why you're not bored out of your skull and completely done with me, but I'll keep doing these as long as you keep watching. Let's do something about it. Remember the Dan Sullivan video I talked about? Don't just get ready to get ready. Go ahead and do something. Call your lawyer, call your accountant, make a chart, think about what you want for your children. Please don't ruin their lives by making it too easy. Don't leave everything outright to them. Make them work at whatever age they are. Come see me in Ave Maria. We will set some goals and achieve some goals. I'm going to add Greatest Hits Part 2 to our schedule. Please remember, I'll go ahead and cover the rest of these things that I didn't get to today. Isn't it silly that I thought I might get to some of these things? Yes, it is. All right, so coming up, the Estate View software explanation. You can watch it here at YouTube. And the software itself, if you're not a client of ours, is only $79.95. It's darn good. Ave Maria, Come see us, then we'll have dinner. Friday, October 8th, Naples, Florida. If you've never been to Naples, it is a beautiful place, especially to be in October. You'll be getting into breakout sessions with law students, talking about goals, talking about eliminating frustration, talking about problem solving. You will come out of this workshop with some great ideas and some great inspiration. So we will see you next Saturday at 11 a.m. Thank you so much for attending. Next Saturday is going to be the Spousal Limited Access Trust. Then the following Saturday, installment sales. The following Saturday, community property trusts and other topics. And then September the 11th, a big day because that's my granddaughter's birthday. We'll be talking about Greatest Hits Part 2. Thank you very much and have a fantastic weekend.